The Supreme Court on Tuesday reserved its verdict on a batch of petitions challenging Section 6A of the Citizenship Act 1955, and this provision actually becomes a focal point in the entire debate related to illegal migrants in Assam and Assam's National Register of Citizens. So in today's video, I'm going to tell you what Section 6A says and why is it so controversial. But before that, let me just take a second. I have an appeal for you guys, an appeal for you to take subscription of ThePrint, because we believe in non-hyphenated journalism. We believe in high quality journalism, fair and questioning journalism, and for that we would just request for your support and request you to become our subscribers. The procedure to become a subscriber is visible on your screens right now, and we've also added the links to the description of this video. That would make the process much easier for you. Of course, becoming a subscriber has a host of benefits again, which is something that you can read on the links that we've provided in the description. So I'd really request you to support us, keep supporting us the way you do, and take a subscription for ThePrint. Now to get back to the video. Essentially, to understand this, we'd have to go back in history like we do in most of my videos. We'll have to go back before the Assam Accord was signed. Before the accord was signed, the All Assam Students Union, or ASU, in February 1980 presented a memorandum to then Prime Minister Indira Gandhi that conveyed their profound sense of apprehensions regarding the continuing influx of foreign nationals into Assam and the fear about adverse effects upon the political, social, cultural and economic life of the state. Gandhi had then initiated dialogue with ASU and the All Assam Ganas Sangram Parishad, or AAGSP. According to the Assam Accord, talks were held at the Prime Minister's and Home Minister's level during the period between 1980 and 83, and then several rounds of informal talks were held during 1984, and formal discussions were then resumed in March 1985. However, in view of the continued large-scale agitations in Assam over the influx of migrants, an accord was signed on 15th August 1985 between ASU and AAGSP and the central government. This accord said that all signatories have been most anxious to find a satisfactory solution to the problem of foreigners in Assam. This accord set the base cutoff date for the detection and deletion of foreigners. It said that those who came to Assam prior to 1st January 1966 would be regularized. Those who came between 1st January 1966 and 24th March 1971 shall be detected in accordance with the Foreigners Act 1946 and the Foreigners Tribunals Order 1964, and their names will be deleted from the electoral rolls in force. So essentially, it required such people, the people falling in the second category, to register themselves, and they would have to wait 10 years before they could be granted citizenship. But this was essentially, in brief, a different procedure that was established for the migrants who were coming into Assam. The Citizenship Act 1955 was then amended in 1985 to insert Section 6A following the Assam Accord. In fact, the Statement of Objects and Reasons attached to the 1985 Amendment Bill spoke of the Assam Accord as a political settlement, adding that a law was required to give effect to the clauses of the accord. And similarly, Section 6A makes special provision for citizenship of people covered by the Assam Accord. This provision classifies illegal immigrants from Bangladesh into Assam in 3 categories. Like I mentioned, those who entered before 1st Jan 1966, those who entered after 1st Jan 1966 and before 25th March 1971, and those who entered after 25th March 1971. And then it said that those belonging to the first category shall be deemed to be citizens of India automatically. Those belonging to the second category shall be detected as foreigners and would then have to register themselves according to the rules made by the central government. These people would be granted citizenship after a period of 10 years and during this period they would have the same rights and obligations as a citizen except for the right to vote. The provision therefore granted benefit of citizenship immediately to all immigrants from East Pakistan who had migrated before 1966, and after a period of 10 years to those who migrated before 25th March 1971, after it had been established that they had in fact settled in India between 1966 and 1971. In fact, the final National Register of Citizens on NRC in Assam that you've heard about before, which was published in 2019, was conducted on the basis of this cutoff date of March 1971. But why has this provision now been challenged in the Supreme Court? The challenge actually dates way back. It was filed by an organization called Assam Sanmilita Mahasangha, which is an organization which says that it advocates for the rights of indigenous communities of Assam. The petition was filed along with 3 other organizations before the Supreme Court in 2012, challenging the constitutional validity of Section 6A of the Citizenship Act. Now, in December 2014, a bench comprising Justice Ranjan Gogoi and Justice R.F. Nariman framed 13 questions and referred them to a 5-judge constitution bench. Why we're talking about these 13 questions is because this will help you understand the sort of challenge that has been mounted against Section 6A. So this included the question whether Section 6A violates Article 21, which is right to life and personal liberty of the Constitution, because it says the lives and personal liberty of the citizens of Assam have been affected adversely by the massive influx of illegal migrants from Bangladesh. The bench also asked whether Section 6A of the Act violates Articles 325 and 326 of the Constitution of India by diluting the political rights of the citizens of the state of Assam. For some context, Article 325 essentially says that no person shall be ineligible for inclusion in electoral roll. So basically, no person shall be ineligible to vote on grounds of religion, race, caste, or sex. And Article 326 says that talks about elections on the basis of adult suffrage. Now, among other things, the bench also sought to know, so among those 13 questions was another question whether Section 6A violates Article 355 of the Constitution, which makes it the duty of the Union to protect states against external aggression and internal disturbance. So the question that they asked, and you can see it on your screens right now, was would an influx of illegal migrants into a state of India constitute external aggression and or internal disturbance? Does the expression state occurring in this article refer only to a territorial region, or does it also include the people living in the state, which would include their culture and identity? Additionally, the bench asked whether Section 6A violates Article 14, which guarantees equality before law, by singling out Assam from other border states and discriminating against it. So essentially, the assertion here is whether there was no rational basis for having a separate cutoff date for regularizing illegal migrants who enter Assam as opposed to the rest of the country, because Section 6A only applies to influx of migrants in Assam. Now, in April 2017, a 5-judge constitution bench was constituted to hear the case. Of course, since then, a few of these judges retired. So, currently, a new bench is hearing the case. And now, finally, after all these years, a 5-judge constitution bench heard the case for 4 days and has reserved its verdict. Now, before the Supreme Court, just to give you an idea of the sort of arguments that the petitioners have taken now, the petitioners have taken objection to a different cutoff date for granting Indian citizenship in Assam than in the rest of India. Just for some context, Article 6 of the Constitution says that any person who migrated to India from Pakistan shall be deemed to be a citizen of India if they migrated before 19 July 1948 and continued to be a resident since the migration. For people who migrated on or after 19 July 1948 and before the commencement of the Constitution, they had to register as a citizen by filing an application. So the petition challenging Section 6A points out that Article 6, so this is different, this is Article 6 of the Constitution, provides for 2 cutoff dates, 19 July 1948 without application and January 1950 with application for acquiring Indian citizenship from those coming from Pakistan. It then asserts that the people of Assam cannot be compelled to waive their fundamental right guaranteed under Article 14 and accept illegal immigrants who have entered the state from 1950 to 1971. So the assertion here essentially is that the petitioners have said that the provision violates Article 14, which is the right to equality, because it carves out a provision exclusively for Assam and it does not do the same for other border states like Bihar or West Bengal. This is a contention that was taken in the Supreme Court during the hearing as well. The petitioners challenging Section 6A argue that the application of 6A to the state of Assam alone has led to a perceptible change in the demographic pattern of the state and has reduced the people of Assam to a minority in their own state. The petitioners have also argued that the provision incentivizes illegal immigrants to continue staying in Assam in violation of the law. They have also objected to the singling out of Assam, like I said, for application of the provision. In response, the centre has told the Supreme Court that the provision is a part of the legislative policy of the Parliament arising from a political settlement, which settlement it's referring to the Assam Accord with relevant parties based on certain relevant considerations of state policy and foreign policy. It has therefore asserted that the provision is not arbitrary and has a rational nexus with the object that is sought to be achieved. Now, after hearing all of these arguments over a period of 4 days, the court has reserved its verdict, and the decision, of course, will be a big one for citizenship law in India, defining and interpreting citizenship law in India. So we'll be keeping an eye out for the decision, of course. I hope you will do the same. Keep an eye out on the print videos as well as the website, and we'll keep you updated on what happens next in the case. Thank you so much for watching.